5 seconds to go. Start. Upon completion of investigation, though on verification by K.K. Rao, DSP DW2, who found the accused innocent, Sub-Inspector Gurdwaya Ram, PW14, IO was of the opinion that there were sufficient grounds for trial and therefore, he filed the charge sheet. Stop. Charges came to be framed for the offence punishable under section 304B of the IPC. Stop. At the conclusion of the trial, the trial court convicted the appellant under section 304B of the IPC. Stop. However, the trial court found that the other two accused, that is, the parents of the appellant were entitled to get benefit of doubt and acquitted them. Stop. The appellant was sentenced to suffer rigorous imprisonment for a period of 10 years. Stop. In an appeal preferred by the appellant before the High Court, though the High Court confirmed the conviction under section 304B of the IPC, it reduced the sentence awarded to 7 years. Stop. Being aggrieved thereby, the present appeal. Stop. Para. We have heard Shri R.K. Rathod, learned counsel appearing on behalf of the appellant, and Shri Piyush Hans, learned counsel appearing on behalf of the state. Stop. Para. Shri Rathod submitted that the trial court and the appellate court have failed to take into consideration that in the very first dying declaration, Exhibit DO/C, deceased Manjeet Kaur had stated that she had consumed the medicine by mistake. Stop. He therefore submitted that the death was accidental. Stop. He further submitted that the second dying declaration, Exhibit PE, which was recorded after 3 days, had been recorded after the parents of deceased Manjeet Kaur instigated her to implicate the appellant. Stop. He submitted that in case of conflicting dying declarations, the accused is entitled to get benefit of doubt. Stop. He therefore submitted that the order of conviction deserves to be set aside. Stop. Para. Shri Hans vehemently submitted that each of the dying declarations has to be appreciated independently. Stop. He submitted that the courts below have rightly found that the first dying declaration, Exhibit DO/C, was given by the deceased Manjeet Kaur under the influence of her husband, whereas the second dying declaration, Exhibit PE, was given by her independently out of her free will. Stop. He further submitted that in view of the concurrent findings of fact, this court should not interfere. Stop. Shri Hans has relied on the following authorities in support of his submission. Stop. The law with regard to dying declaration has been summarized by this court in the case of Lakhan Supra, wherein the court considered various oral judgments on the issue and observed thus, para. In view of the above, the law on the issue of dying declaration can be summarized to the effect that in case the court comes to the conclusion that the dying declaration is true and reliable, has been recorded by a person at a time when the deceased was fit physically and mentally to make the declaration, and it has not been made under any tutoring, duress, prompting, it can be the sole basis for recording conviction. Stop.